I look at this as a way to bring provocative speakers who will make you think about ideas maybe you hadn't thought about before. I didn't know who Sidney Powell was. Somebody gave me a book in February of last year, and I wasn't, people give you books, and are you going to read it? You're not going to read it. I started reading, it was great, and I highly recommend her book. It's called A License to Lie. I think she has other books, but that's the one I'm familiar with. And it's about prosecutorial abuse. I won't steal her thunder, I'll let her talk about it. But I think it's intriguing because we all want sort of justice, and then we have to define what justice is. There's a couple things about the legal system that I think are really important, and from reading other scholars on this, is one, that there's a burden for the state. You don't have to prove that you're innocent. So when you hear people say, well, we can't absolutely say they're innocent, well, that's a ridiculous notion and has no place in even the discussion of guilt and innocence. You don't have to prove your innocence. The burden's on the state. That's how we set it up in our country. That's an incredible, important part. Second thing, it's an adversarial system. You got an advocate on each side. That's why I've been a little worried about the FISA court, because there's only the government and there is no advocate for the defense. We sort of set it up with this. There might be, but it's really not a true court. Plus, a true court needs to be in public. You need to have a public airing of the testimony. And then finally, there have to be some rules for the prosecution not to lie and hide evidence. And this is something Ms. Powell has worked a great deal with. She's not only famous for this book, but she had some famous cases that she talks about in the book that were related to Merrill Lynch and the big Enron case. And then also she's involved with a high-profile case right now with General Flynn. But I would like to bring to the podium famous author, great lawyer, Sidney Powell.
Thank you so much, Senator Paul, for inviting me, and the fund for putting this on, and Nancy Einhorn for all her generosity that makes it possible. And thank you all for your time. Please know and remember that your time is the greatest gift you can give anyone, because it's the only asset you have that cannot be replaced. So your being here today and your work here on the Hill speaks a lot about who you are and who you want to be and what you care about with respect to our country. So thank you all very much. I'm honored and humbled to be able to speak to you today. In 2000, I was sitting at my desk in Asheville, North Carolina, paying little attention to anything in the news when all of the Enron information exploded in the press. And of course, it collapsed in a wave of accounting scandals. In a few weeks, Arthur Andersen partners were sitting up here on the Hill testifying and admitted shredding documents, which immediately prompted the appointment of a new task force, the Enron Task Force, untethered from the Department of Justice because of the Bush connection to Ken Lay. And that task force was handpicked by a number of high-profile people in the Department of Justice, including Robert Mueller and Michael Chertoff and Larry Thompson and others. And remember, this was during the Bush administration. That task force then set about to indict Arthur Andersen for something that was not even a crime. They did it by piecing together parts of different statutes to make a crime up out of something that wasn't, and destroyed Arthur Andersen, and with it 85,000 jobs, only to be reversed by the United States Supreme Court in a unanimous decision 2 years or 3 years later. After they got the conviction of Andersen on a made-up crime, they targeted the Merrill Lynch executives for a relatively minor transaction that wasn't even material to Enron's shareholders. And in a case where Enron had actually made, I think it was $53 million on the deal, in the process of doing that, they again made up a crime. And not only did they make up a crime there, they actually yellow highlighted and hid evidence that they knew favored the defense, and they managed to hide it for 6 years. It was only by accident in the preparation for a second trial of a Merrill Lynch executive that the government accidentally produced to us a disc that contained the yellow highlighting of what's called Brady material, exculpatory evidence favorable to the defense, that the government had identified before the first trial of the Merrill executives and hidden for 6 years. They sent 4 innocent Merrill Lynch executives to prison on an indictment that did not state a criminal offense, while they hid the evidence that showed they were innocent. Those prosecutors then became President Obama's longest-serving White House counsel, General Counsel Deputy Director of the FBI, none other than Andrew Weissman, President Obama's counterterrorism advisor, President Bush's Assistant Attorney General for the Criminal Division of the Department of Justice, who then micromanaged the prosecution of Senator Ted Stevens, which had to be thrown out after costing him his seat in the United States Senate. It was thrown out because they had, again, hidden evidence that showed his innocence. We have a serious problem in this country with unfettered prosecutorial power and with what I call over-criminalization. Harvey Silverglade wrote a great book called 3 Felonies a Day that I would also commend to your reading. And the underlying premise is that there are so many laws that can or have been criminalized by either well-meaning or, at worst, overly aggressive prosecutors, that any one of us, there but for the grace of God, go any one of us, if a prosecutor wants to indict you and send you to prison, they can do it. They have no supervision to speak up. There's no check and balance, really, on the power of the grand jury. The old expression is a prosecutor can indict a ham sandwich. That's definitely true. If you recall, Mr. Mueller indicted a company that didn't exist. All kinds of things can happen when prosecutors have absolutely unlimited discretion in creating charges and indicting people. One of the things that I like to talk about is the need for significant criminal justice reform. Regardless of which side of the aisle you're on, I think most people can agree that we have far too many people in prison for too long and for things that really don't need to be criminalized. Prison is a huge waste of time and resources, probably except for the dangerous people that obviously cannot be allowed into society. We need to come up with more creative ways to punish people in a way that's effective, but still allows them to spend time with their families, be tax-paying and productive, and contribute to society instead of just being locked in a hole and treated like an animal. I'm also very concerned about issues within the Bureau of Prison itself. Frankly, it is a big cesspool. It needs a major overhaul because there are crimes committed in prisons every day on both sides of the bars, and that needs to stop. Harvey Silverglade and I are working together on a book called Conviction Machine, in which we're going to propose solutions for criminal justice reform. You all are the future of this institution and the country. I am hoping that you will read License to Lie, because it's true, it names names, and it reads like a John Grisham novel, so people say it's just a good read. And then also think about what you can do and how you can contribute to working toward criminal justice reform and making the entire system better. You are going to be the people who can do the most good in that arena. There is a lot of work to be done. It shouldn't matter which side of the aisle anyone is on these issues. We can do better, and we must do better. In 1935, the Supreme Court wrote a decision called Berger versus United States. And in it, the Supreme Court explains that the Assistant United States Attorney, or the United States Attorney, is the representative of the sovereign. When you walk into a courtroom and you say, "My name is Sidney Powell, I represent the United States of America," you have a legal, constitutional, and ethical obligation to do it right and to get it right, because you are bringing the full weight and might of the United States government against an individual to deprive them of their life and liberty. Our criminal justice system now literally crushes people to dust. It is virtually impossible to mount a defense against a multi-count federal indictment. The conviction rate of prosecutors is over 95%. Now, a lot of those are guilty pleas, but even on trials, the conviction rate is over 95%. We have lost the presumption of innocence. People think that once somebody is indicted, the charges are real, when they can be as concocted as the Arthur Anderson indictment or the Merrill Lynch indictment. We need to remind ourselves every day not to rush to judgment on anything we read in the newspaper or in an indictment, because it may very well not be true. There is a lot to think about on these issues. I would also commend you to look at the work of the Innocence Project. Every week they free someone who had virtually no opportunity for a defense, who was ground to dust in the system. Maybe they had some prior offenses, maybe they were down on their luck. They didn't have the resources, they didn't have the social standing, they didn't have the public support or anything needed to fight the charges brought against them. They were actually innocent of charges, and they have spent decades in prison on the basis of wrongful convictions, over 50% of which are attributable to prosecutorial misconduct. Prosecutors, according to a Supreme Court decision, enjoy absolute immunity. A prosecutor could indict you tomorrow, send you to prison for 5 years on something you didn't do, and you have absolutely no recourse against them even when you're cleared. One of my Merrill Lynch clients, my primary Merrill Lynch client, currently stands still convicted of perjury and obstruction of justice for expressing his personal understanding of a telephone call he was not even on after Andrew Weissman and the grand jury instructed him to share that understanding, whether it was accurate or not. We could not get that conviction reversed. It's the only 2 convictions that stand out of I think it was a 7-count indictment against the Merrill Lynch executives, against 4 Merrill Lynch executives. One of the young men that was indicted and sent to a maximum security federal transfer facility hundreds of miles from his young family was actually acquitted by the Fifth Circuit after spending 8 months in an absolute hellhole. We have to do better. The ball's going to be in your court, and to a large degree, to see what you can do to make things better. If you get a chance to intern with the Innocence Project, take it. They need all the help they can get. They work tirelessly on behalf of people who have been horribly abused by our criminal justice system. Think about the role of prosecutors in our society, what reasonable limits can be placed on their authority, what checks and balances can be placed to evaluate indictments or prosecutions before they go on and on and on. Another thing in the Merrill Lynch cases, those men dealt with that for 10 years. The Enron Task Force prosecutors took some people to trial as many as 3 times. Some people finally pled guilty facing a 3rd trial because they just couldn't take it anymore. The litigation consumed the entire teenage years of my clients' children. You cannot begin to imagine the stress it places on a family and their friends and their children and their friends even to be the focus of a federal criminal prosecution. So we need to find a way to make prosecutors think long and hard before they indict people, to make sure they are indicting the right person for the right reasons and for real crimes, and find a way to make the entire system work better.